Hello, viewers. Welcome to another lesson. In today's lesson, I shall be taking you through the offenses of incitement and treason in Sierra Leone. The objective of this lesson is for you to know where the laws on incitement and treason are and to understand their elements and punishment. Now, incitement has been defined as common law, and the common law definition given to the offense of incitement is that incitement is an offense of suggesting, encouraging, persuading, influencing, threatening, pressurizing another to commit an offense as opposed to a civil wrong, and that the suggested or incited crime did not have to be committed. Now, this definition has elements, and the first is suggesting. Suggesting is synonymous to proposing. Encouraging is synonymous to supporting. Persuading is synonymous to convincing. Influencing is synonymous to manipulating. Threatening is synonymous to instilling fear. Pressurizing is synonymous to pesting or panting. And all of these are geared towards influencing someone or instigating someone to commit the offense. An offense. So the offense could be to assault, and that assault is achievable through the inchoate offense of incitement. And the last element states that incited crime did not have to be committed. So, in other words, you start the mere starting or preparing for the commission of that offense, which is assault, is incitement. So it does not necessarily mean that you, being the inciter, you are the very one who is going to execute the offense of assault. Now, the inchoate offense of incitement has been recognized in Sierra Leone under Section 11 of the Public Order Act of 1965, and it states that every person who takes part in any affray or incites any other person to take part in or comments any affray shall be guilty of an offense. And an affray is defined under this section as any fight between two or more persons in the witness of someone who doesn't participate in it but apprehends fear as a result of that fight. And incitement, the element of incitement has already been discussed earlier. Now, to treason. Treason has been defined under Section 3, subsection 1 of the Treason and State Offences Act of 1963. Now, the offense of treason is captured as follows: that a person who is guilty of treason shall, on conviction, be liable to suffer death, who either within Sierra Leone or else prepares or endeavors to overthrow the government by unlawful means. So it is the preparation or endeavoring to overthrow the government by unlawful means. So that's treason. Now, the elements of this offense as captured under Section 3 are as follows: that firstly, one has to prepare or endeavor. In other words, one has to take steps, if not the full execution of, if not the full execution, but one has to take steps at least. Then, secondly, one has to overthrow. That is another step in the execution of treason of the offense itself. So, overthrow is like to usurp, to take over, and you have to take over what? A government. So, it doesn't mean that when you take over an office that is not described within the word government is treason. So it has to be a government, and a government is commonly described as an institution that comprises the three arms of government. That's the three arms of governance. We have the executive, the judiciary, and the legislature. Now we also have the fourth element, which is by unlawful means. So in other words, if a president's term has expired then you overthrow that president, it is not unlawful. So it only becomes lawful when the time has expired but the president refuses to step down or to hand over power, then you can lawfully overthrow. But as long as the time has not expired, then you overthrow, then that becomes unlawful. Now, treason has a punishment, and as captured under Section 3, subsection 1 of the Treason and State Offences Act, it has to be death. But the Criminal Procedure Act recognizes it under Section 211. Now, however, this punishment of death has an alternative, and this alternative was articulated in the case of the State versus Omri Golli and others 2007. And Section 3, subsection 1 of Section 3, subsection 1 of the Treason and State Offences Act was articulated that which establishes treason confers a discretionary power on the judge or any court to impose an alternative penalty upon conviction for treason. And this was articulated by Justice M.C. So in other words, that though death has been recognized under Section 3, subsection 1 of the Treason and State Offences Act, there is an alternative wherein the judge can give an alternative to that sentence, that statutorily recognized penalty of death. Also, to get more information on this alternative, you can also look at the case of Mohammed Sori Fona against the state 1975, because this particular case was used and highly influenced the statement by Justice MC. Thank you for listening. Thank you for watching. Please don't forget to